Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. As always, I will be starting with the update from the Constitution Bench hearing the batch of petitions which challenge dilution of Article 370 of the Constitution. Today was the 12th day of the hearing before the bench of CJI Chandrachud, Justice S.K. Kaul, Justice Sanjeev Khanna, Justice B.R. Gawai, and Justice Suryakant. S.J. Tushar Mehta, appearing for the Union government, continued with his arguments today. There was a lively discussion regarding the powers of the Parliament to convert a state into a union territory. Yesterday, as you know, the SG had informed the court that bifurcation of the state was a temporary measure. Today, again, he reiterated that the statehood of Jammu and Kashmir would be restored while Ladakh would be retained as a union territory. He also said that except for police and public order, all other powers did lie with Jammu and Kashmir. Significantly, the Supreme Court has asked the union government to provide a time frame or a roadmap for restoration of statehood. The CJI emphasized that while national security concerns were understood, the restoration of democracy in the region was equally vital. At the end, the CJI also said that the wide difference between absolute autonomy as it existed in 1950 and the complete integration as brought in August 2019, that difference had already been substantially bridged by what had happened in between. That a substantial degree of integration had already taken place in the 69 years. He further questioned whether the act of abrogation was really a logical step forward to achieve that integration or not. The hearing in the matter will continue tomorrow. You can also follow the live updates from the hearing on our website. The Supreme Court today refused to interfere with the order of Punjab and Haryana High Court, which had earlier this month stayed the elections of Wrestling Federation of India, or WFI. The High Court had passed the order in a petition filed by Haryana Wrestling Association, that is HWA, objecting to inclusion of Haryana Amateur Wrestling Association in the Electoral College for the WFI elections. HWA contended that the Haryana Amateur Wrestling Association was not fully affiliated to the State Olympic Association, which is a precondition to vote in the WFI elections. Yesterday, as the matter was listed before the High Court, it extended the interim stay till 25th September. A special leave petition was filed by Andhra Pradesh Amateur Wrestling Association against the previous stay order before the Supreme Court. But the Supreme Court bench, comprising Justices Abhay S. Oak and Pankaj Mittal, refused to interfere and asked the petitioner to approach the High Court seeking the vacation of the interim order instead of approaching the Supreme Court. Let me tell you here, recently United World Wrestling, the global wrestling body, suspended the membership of WFI over its failure to conduct elections. This means Indian wrestlers will not compete at the World Championship under the Indian flag, but as neutral athletes. Originally, the WFI was to hold elections on 7th May, but the Sports Ministry declared the process null and void due to the wrestlers' protest against the outgoing WFI president, Brij Bhushan Sharan Singh. And there has been more delay due to the multiple disgruntled and disaffiliated state bodies moving the court seeking right to participate in the polls. And now an update on another controversy involving the Delhi Chief Minister and Aam Aadmi Party Chief Arvind Kejriwal. This controversy is over his alleged remark made at a political rally in 2014. The remark was, "Those who believe in Khuda won't be pardoned if they vote for Bharatiya Janata Party." This resulted in the lodging of an FIR against Kejriwal under Representation of the People Act for allegedly violating the Model Code of Conduct. In September 2014, a trial court took cognizance and summoned the AAP leader, after which he moved the High Court and the Supreme Court seeking various reliefs. But he was turned away with a direction to approach the trial court for redressal of his grievances. He then moved the Sessions Court and the High Court as well, but could not get any relief. Finally, after exhausting all his remedies, the AAP leader moved the Supreme Court, challenging the Allahabad High Court's decision to decline his plea for setting aside order of Sessions Judge and dismissing the criminal proceedings against him. In February, while issuing notice, the Supreme Court had granted interim relief and put a temporary halt to the trial proceedings, which was later extended in May this year. Today, the Supreme Court bench of Justices M.M. Sundaresh and J.B. Pardiwala adjourned the hearing until the last week of September at the legislator's behest. A request was made on his behalf to be granted more time to file a rejoinder to the state government's counter affidavit, to which the state had no objection. The Supreme Court has imposed a cost of 2 lakh rupees on the Dakshinanchal Vidyut Vitran Nigam Limited, a state undertaking distributing electricity power in Uttar Pradesh, while dismissing its challenge to a labor court award passed for paying salary arrears to a workman. In this case, the petitioner was initially employed as a workman in the electricity department in October 1977 on muster roll. His service was unlawfully terminated in 1979. He moved to the labor court, which gave an award in his favor in 1995, directing his reinstatement and paying off back wages. The electricity department challenged this award before the High Court, and the High Court dismissed the award in 2006, that is, after 11 long years. The petitioner sought recourse through the Labour Court once again by filing a petition under UP Industrial Disputes Act, which calculated the due amount and directed payment in 2020. This decision, however, was set aside in an impugned order, prompting the petitioner to approach the Supreme Court. The bench, comprising Justices S. Ravindra Bhatt and Justice Arvind Kumar, directed the corporation to pay the workmen a sum of rupees 10,54,000 rupees towards salary arrears from 1995 till 2006, along with 11% interest till the date of payment. Further, the corporation was asked to pay a cost of 2 lakhs. The Supreme Court maintained that the directions in the original award in 1995 had crystallized the issues and that the subsequent proceedings were essentially in the nature of execution. The Supreme Court has reiterated an important point of law under the Hindu Succession Act. That is, for a Hindu female to claim rights under Section 14 of the said Act, she has to be in possession of the property. This Section 14 states that property of a female Hindu will be her absolute property, making her the full owner and not a limited owner. The instant case was a civil appeal arising out of a suit filed in Kerala. The trial court, appellate court, and the High Court had concurrently ruled against the plaintiffs by holding that the woman from whom they sought to derive their rights was never in possession of the property, and hence Section 14 Clause 1 was not applicable. The bench, comprising Justices C.T. Ravi Kumar and Sudhanshu Dholia, dismissed the SLP, confirming the decree of the trial court, and observed that the Hindu female must not only be possessed of the property, but she must have acquired the property. Such acquisition must be either by way of inheritance or at a partition or in lieu of maintenance or arrears of maintenance or by gift or by her own skill or exertion. To know more about the case, please visit our website at livelaw.in. A fresh application has been filed before the Court of District Judge Varanasi to direct the Archaeological Survey of India, that is ASI, to undertake a survey of the Vazukhana area except for Shivling without causing any damage to the structure. The application states that the survey is necessary to ascertain the religious character of the property, thus seeking a scientific investigation of the protected area excluding the Shivling in the Gyanvapi premises. The application has been filed in the already pending Shringar Gauri worshipping suit. It may be noted that the ASI is presently conducting a scientific survey of the Gyanvapi complex in Varanasi to determine if the mosque was constructed over a pre-existing structure of a Hindu temple or not. Today is the 26th day of the survey. Another application is pending before the Varanasi court to preserve artifacts and other materials found by the ASI during its ongoing survey. In the next update, Sharjeel Imam has moved a Delhi court seeking statutory bail for having undergone one half of the maximum 7 years punishment in a UAPA and sedition case relating to alleged inflammatory speeches made by him at Aligarh Muslim University against the Citizenship Amendment Act in December 2019. Imam was booked under an FIR registered by the Delhi Police's special branch. While the case was initially registered for the offence of sedition, UAPA was invoked later. He has been in custody since January 2020. His application states that he is entitled to be released on statutory bail as he has undergone one half of the maximum 7 years of punishment prescribed under UAPA and that he is ready to furnish reliable surety to the satisfaction of the court and also to abide by the conditions or restrictions imposed on him in case of his release. The application will be heard by Additional Sessions Judge Amitabh Rawat of Karkar Duma Court on September 11th. Also, if you remember, in June this year, Imam had moved the Delhi High Court challenging proceedings against him in two different cases for the same speech delivered at Jamia. Notice has been issued in the matter and the hearing is scheduled on 18th October. And lastly, the Odisha High Court has directed the Cuttack Municipal Corporation, that is CMC, to relocate all the stray dogs wandering around the campus of National Law University, Odisha, within 24 hours. This was due to the incident of stray dogs repeatedly attacking a first-year student of the institution who suffers from cerebral palsy and 65% disability. A PIL was filed by the law school and it was averred that the student had been chased by the stray dogs 15 times and bitten 7 times within the last 1 month. He was last attacked on 26 August and had to take anti-rabies injection each time after the attack. It was further submitted that the dogs were not the original habitants of the university but had migrated from nearby locations, and unless they were relocated, normalcy would not return to the campus. Accordingly, the division bench of Chief Justice Subhashish Talpatra and Justice Savitri Ratho directed the CMC to engage the concerned squad under supervision of health officer for relocating all the stray dogs. The CMC was also asked to file a compliance report within 24 hours. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.